Good morning and welcome to this privilege update presentation hosted by BCL Legal. My name is James Quinn and I'm a solicitor in the dispute resolution team at Boys Turner Solicitors in Reading. Co-presenting with me this morning is Anne Bell-Barons, who is also a solicitor in our team. In our presentation this morning, we'll run through 5 interesting cases in the High Court and Competition Authority Tribunal from earlier this year, in which rulings have been given on different aspects of the law of privilege. In 2020, we saw the landmark Court of Appeal ruling on legal advice privilege in Jet 2 and the Civil Aviation Authority. And although there haven't been any landmark cases on quite that level this year, the cases which we'll run through today are significant nonetheless, and they've arisen in interesting scenarios which should, as always, give us all pause for thought on privilege issues arising in our day-to-day work. We'll complete our run through within the half-hour slot this morning, and please do feel free to email in any questions to BCL and we'll come back to you after the webinar. First case we'll look at this morning is Kyler Shipping and Freight Trading Limited and others. This was a decision from the commercial court proceedings before Charles Hollander QC, sitting as the Deputy Judge of the High Court. The decision was given on an interim application for specific disclosure shortly before the trial of the proceedings. In the application, the defendants challenged the claimant's claim for litigation privilege over communications with an expert and communications in relation to the expert. The second element of the application concerned whether the reference to certain matters in a witness statement amounted to a waiver of privilege in those matters, obliging the claimants to disclose materials referred to in the statement. Let's start then with a summary of the underlying dispute. The claim relates to a series of 41 forward freight agreements entered into between Kyler and FTL, and in one case between Kyler and FTL or the second defendant. Claimants allege that the FFAs were entered into by the third defendant, CTM, through the fourth defendant, Mr. Caffiero, at off-market rates in order to enrich FTL or CTP, who were at the time in the same corporate group as CTM at the expense of Kyler. This was referred to as the mispricing claim. The defendants denied that CTM acted as agent for Kyler. They alleged that the FFAs were concluded by Kyler by its own principal and Mr. Nikolaos Livanos. Kyler was 70% owned by Nikolaos Livanos and 30% by a company called Ypa, in which Mr. Peter Livanos had an interest. Ypa was an associated company of one of the defendants in the mispricing claim, FTL. In 2018, a dispute arose between Kyler and its shareholders concerning a payment of a dividend arising from the constructive total loss of a vessel. This was referred to as the Ypa dispute. The defendants in the present litigation accepted that by the end of October 2018, litigation was in reasonable contemplation in the Ypa dispute, and that litigation privilege could be claimed by Kyler for documents created for the dominant purposes of that dispute. In late October 2018, a dispute arose between the Ypa and its shareholder, Nikolaos Livanos, alleging in correspondence in November 2018 that there had been mismanagement by YPL in relation to the entering into of the FFAs. In October 2019, Kyler commenced commercial court proceedings against the defendants in respect of the mispricing claim. The claimants applied for permission for service out of the jurisdiction, and in a witness statement that was filed by their London solicitors in support of the application. In the witness statement, it explained that in November 2018, Nikolaos Livanos instructed the firm of accountants to carry out an analysis of the FFAs, and he decided that it was appropriate to appoint an expert to audit the FFAs. It was said that this would allow him to make good any legitimate grievance that might exist for the sake of providing ballast in the correspondence with YPA and Peter Livanos in the YPA dispute. Kyler went ahead and appointed the expert in late 2018, and it was stated that following the expert's review, an apparent fraud was identified and which became the mispricing claim. In a later witness statement from the claimant's London lawyer, it was stated that litigation in relation to the YPA dispute was in reasonable contemplation by 31st of October 2018, and that when the claimant's London lawyers were instructed on 26 November 2018, litigation was in reasonable contemplation in relation to the mispricing claim. In the mispricing claim proceedings, the claimants claimed privilege in documents relating to the investigations in the FFAs in a form of communication between the lawyers, third parties, and experts for the purposes of litigation. The issue for the court was whether litigation privilege could be claimed over communications with the expert before the crystallization and discovery of the mispricing claim. The court considered the authorities on the test for establishing a claim for litigation privilege. Summarizing this just briefly here, the judge said that the party claiming litigation privilege must show that the document in question was created for the dominant purpose of conducting litigation in reasonable prospect. Referring to the War and British Railways Board case, it is insufficient if the document was created for 2 equal purposes, if only one of those purposes was a privileged purpose. In Starr, Berth and Interbrew, as we see on the slide, the court summarised the test for establishing whether litigation is in reasonable contemplation and this has to be more than a distinct possibility or general apprehension of litigation. In Cengiz, the judge stated that there needn't be more than a 50% chance of litigation, but litigation must be more than a mere possibility. The communications will need to be for the dominant purpose of enabling legal advice to be sought or given, and or seeking or obtaining evidence or obtaining for the anticipated proceedings. The defendants argued that the evidence did not support the contention that the documents were created from November 2018 for the dominant purpose of the dispute at that stage, wholly unknown to Kyla. They submitted that the instruction of an expert at that time was a fishing expedition. The claimant submitted that litigation was in reasonable prospect in the Ypa dispute, and the expert was instructed for the purpose of bringing a counterclaim in those contemplated proceedings. As we see on the slide, the judge decided did not consider that the dominant purpose was for litigation in reasonable prospect. The dominant purpose of instructing the expert was to support Nikolaos Livanos' allegation of mismanagement in his correspondence with Peter Livanos, and litigation in relation to the mismanagement claim was not in reasonable contemplation when the expert was instructed. Consequently, the court ordered the claimants to reconsider the claim for litigation privilege on the basis that it could not be claimed for the mismanagement claim that may be claimed when litigation was in reasonable contemplation in respect of the mispricing claim. This underlines the need for proceedings to be contemplated for a specific known dispute for litigation privilege to apply. Instructing an expert to look into matters which might identify a potential new dispute will not be sufficient to attract litigation privilege. The next issue for the court to decide was whether Kyla's lawyer's witness statement referred to privileged materials and whether this amounted to a waiver of privilege in those materials. Further, if there had been such a waiver, did that create a collateral waiver over further related documents? The judge summarized the issue was whether there had been reliance on the contents or the effect of the privileged material, with reliance on the contents giving rise to a waiver. The judge concluded there had not been a waiver. There had been no reliance on any particular document, and indeed the witness statement did not expressly refer to any specific documents. The absence of references to express documents in the witness statement was therefore a key factor in the judge's conclusion that there had been no waiver. And this is a reminder of the risks of waiver where references are made to privileged documents or to documents where there is likely to be an argument as to their privileged nature. Next, we'll look at the case of Lawley Financing and Credit Suisse. This is an interesting commercial court case in which the court was asked to rule on whether the identity of individuals at a company responsible for instructing external counsel was protected by litigation privilege, or whether litigation privilege did not apply and the names of the individuals should be disclosed. In the case, the Credit Suisse defendants were challenging claims by the claimant to legal professional privilege. As we see on the slide, the central question was, is the identity of the persons who were authorized to give instructions to solicitors on behalf of a corporate client in ongoing litigation a matter which is covered by litigation privilege? The claimant's legal team submitted that there was no previous authority which addressed this specific question, and that Credit Suisse was effectively asking the court to create an exception to the application of the litigation privilege rule such that it would cover all aspects of a party's preparation for litigation, except the identity of the persons authorized to give instructions. In the litigation, Lawley was alleging fraud against Credit Suisse in relation to its purchase of financial instruments from the bank, including claims of fraudulent misrep and unlawful means conspiracy. Limitation was an issue, and one question was what information relating to its claim Lawley knew or could have known before November 2012 or 2015. Lawley is an SPV with no employees and with directors supplied by a professional services company. IKB Deutsche Industriebank AG, or IKB, was the sole liquidity provided to Lawley. Credit Suisse alleged that Lawley was reliant on IKB for its record keeping. IKB Credit Asset Management was Lawley's investment advisor for the purchase of the financial products from Credit Suisse. Another German financial institution, KfW, rescued IKB in 2007, and Credit Suisse alleged that KfW took over as the liquidity facility provider to Lawley. Credit Suisse alleged that KfW initiated or was otherwise involved in the decision to commence the current litigation and appeared to be providing instructions to Lawley's London solicitors on behalf of Lawley. Lawley accepted that the question, who gives instructions to Lawley's London solicitors, was relevant to the limitation issue, and if KfW or IKB provide instructions to the London lawyers, Credit Suisse would argue that the knowledge of KfW or IKB is attributable to Lawley. In the litigation, Credit Suisse requested confirmation from Lawley under the civil procedure laws as to whether IKB had decided to pursue the litigation and whether individuals at KFW were providing instructions to Lawley's London lawyers in relation to litigation. In response, Lawley said that the information was irrelevant and in any event subject to legal professional privilege. Credit Suisse sought orders from the court that the names of the individuals who are or have been authorised to give instructions to Lawley's London lawyers are not subject to legal professional privilege. Credit Suisse admitted that legal professional privilege protects communications, not fact. The identity of the person giving instructions to the lawyer is not privileged. The bank did not seek any information as to the content of communications between solicitor and client. In response, Lawley's position is that the identity of persons authorised to give instructions is itself an aspect of those instructions. It argued that it is within a zone of privacy around a party's preparation for litigation, and that is the purpose of litigation privilege to establish. As we see on the slide, the court found that the answer to the question whether the identity of a person communicating with a lawyer is privileged lies in whether two requirements are met. First, whether the communication is privileged. Second, whether that privilege will be undermined by the disclosure of identity sought. This answer applies as much where the person communicating does so as a person authorised to give instructions to the lawyer on behalf of the lawyer's client, as where that person has a different role. As we see on the slide, the court concluded on the facts of the case that privilege would not be undermined by the disclosure of the identity of the persons giving instructions. Lawley had argued that the identity of the persons giving the instructions may give the other party clues as to the content of particular instructions or the client's litigation strategy, and this might discourage a client from instructing a particular individual to give instructions on its behalf. The court made clear that each case will turn on its own facts, and in this case, the court accepted Credit Suisse's argument that there was no evidence that revealing the identity of the person would give clues as to the content of particular instructions. Furthermore, the court pointed out that there was no suggestion in the case that the identity of the authorised person was only available from privileged communications. This is an interesting decision which illustrates that a communication which is subject to litigation privilege may not be subject to what was described as a zone of privacy, and that the identity of the persons giving instructions may be disclosable even though the communication itself may be protected by litigation privilege. I'll now pass over to Annabelle, who will run through two cases dealing with legal advice privilege and loss or waiver of privilege.
Hello. So the first case I'll be dealing with is the Northumbria healthcare case. And this relates to a construction dispute whereby the claimants allege that the defendants failed to properly design and construct a new hospital. The element of this case that relates to privilege was addressed at a CMC after the claimants made an application for specific disclosure pursuant to CPR 13.12. The claimants made an application for disclosure of documents referred to in emails sent throughout October and November 2019 to and from Mr. Smales, who is a former employee of the first defendant. In addition, they requested a witness statement from the defendants addressing A, the steps that were taken by the defendants to preserve the hard copy documents, B, the steps which were undertaken by the defendants to search for the hard copy documents, C, the steps undertaken by the defendants to search for any electronic copies, the search techniques that were adopted by the defendants, and whether any of the hard copy and electronic documents had actually been located. The application was opposed in part by the defendants on the following grounds. They claim that the documents referred to in Mr. Smales' emails had either been disclosed but were withheld from inspection because they were covered by litigation privilege or legal advice privilege, or that the documents were irrelevant and covered by litigation privilege. The defendants did accept that some of the documents had been located, digitised, and where relevant, disclosed. A brief timeline of the relevant events of the litigation is shown on this slide. In July 2019, the claimant served their pre-action letter of claim. From the 7th of August 2019, the defendants and their solicitors had weekly strategy meetings, and on August the 16th, 2019, the defendants produced a list of individuals who constituted the instructing client and were responsible for seeking and/or receiving legal advice from the solicitors in relation to the dispute. And importantly, this list included Mr. Smales. Mrs. Justice O'Farrell relied on the following authorities when giving her decision in relation to the litigation privilege. Practice Direction 51U provides that a party who wishes to claim a right or duty to withhold disclosure or production of a document, part of a document, or class of documents, which would otherwise fall within its disclosure obligations, may exercise that right by describing the document or class of document and explaining the grounds on which it claims that right or duty. The requirements for litigation privilege were set out in 3 rivers, as shown in the slide. A, litigation must be in progress or in contemplation. B, the communications must have been made for the sole or dominant purpose of conducting that litigation. And C, the litigation must be adversarial, not investigative or inquisitorial. As James mentioned previously, in Starbev, GP and Interbrew, the legal requirements of a claim to litigation privilege are summarised as follows. 1, the burden of proof is on the party claiming privilege to establish it. 2, the court will scrutinise carefully how that claim to privilege is made out, and any witness statements in support should be as specific as possible. And 3, the party claiming privilege must establish that litigation was reasonably contemplated or anticipated. It is not sufficient to show that there was a mere possibility of litigation. In relation to the legal advice privilege, paragraph 31.3.6 of the White Book states that the test for legal advice privilege is whether the communication or document is made confidentially for the purpose of legal advice. It was held that these purposes have to be construed broadly. In Jet 2 and Civil Aviation Authority, the Court of Appeal confirmed that for communications or documents to fall within the scope of legal advice privilege, they had to be created or sent for the dominant purpose of seeking legal advice. Crucially, such privilege extends to internal communications where an employee has been tasked with seeking and receiving such legal advice. In Jet 2, it was held where the relevant client is a corporation, documents or other materials between an employee of that corporation and a co-employee or the corporation's lawyers, even if required or designed to equip those lawyers, to give legal advice to the corporation, do not attract legal advice privilege unless the employee was tasked with seeking and receiving legal advice on behalf of the company. In this case, the court was satisfied that the claim to legal advice privilege was established in respect of the documents. Firstly, the defendant had set out in detail in a witness statement the circumstances in which the documents were produced. Secondly, the documents were produced after the letter of claim had been received, therefore litigation was in contemplation. And thirdly, Mr. Smales was identified as one of the individuals who constituted the instructing client and was responsible for seeking and or receiving legal advice from the solicitors in relation to the contemplated litigation. Finally, the documents were produced as part of the work streams identified in the strategy meetings formed for the purpose of conducting the litigation. The next case that I'll discuss is Superpat and others and Siam Commercial Bank. This case addresses whether privilege in documents can be lost. In this case, there were multiple claimants and defendants involved in various litigation surrounding companies based in Thailand. The claimants in these proceedings obtained through the courts in Thailand in separate litigation some documents which one of the defendants, SCB Bank, claim are covered by privilege. Importantly, SCB, who are the owner of the documents, wasn't a party to the Thai litigation and wasn't aware of the application for the documents at the time it was made. In this case, SCB applied for an order prohibiting the respondents from using or deploying in these proceedings certain documents covered by SCB's legal professional privilege, copies of which the respondents had obtained pursuant to subpoenas in Thailand. They also applied for an order requiring the claimant's legal team in these proceedings to return their copies of the documents obtained in Thailand. The respondents submitted that the documents are not privileged for 3 reasons. Firstly, they claimed that they held copies of the documents lawfully pursuant to the Thai subpoenas. Secondly, they claimed that the documents had been circulated by or on behalf of SCB to other parties and therefore they'd lost their confidentiality. And in any event, they claim that the documents fall within the iniquity exception and therefore were never privileged at all. The judge addressed each of the respondents' points in turn. Firstly, are the documents capable of being privileged? The judge concluded that whether a document is capable of being privileged is a question to be determined as a matter of English conflicts law by the lex 4I, which in this case is English law. He said that applying this principle leads to the obvious conclusion that the documents are privileged, subject to the other defences. The next question the judge addressed was a subpoena issue. Had the documents lost their privilege because of their release under the tie subpoenas? It was held that whether confidence has been lost is a contextual and factual question. The judge said that where the issue concerns the loss of privilege, which is protected in England as a matter of public policy, a court should be very slow to conclude that the necessary level of confidence has been lost in circumstances such as this. In issuing the subpoenas, the Thai courts did not and could not direct that the documents delivered up as a result would be admissible or disclosable in English litigation before an English court. For these reasons, he considered that all of the issues concerning legal advice privilege, including whether a document and its contents remains confidential in the sense that they are not properly available for use before the courts of England and Wales, are to be resolved by reference to English law. He concluded that, subject to the dissemination and inequity issues, the material was and remains privileged as a matter of English law. The dissemination issue: had the documents lost privilege because they were circulated by or on behalf of SCB to various third parties? The authorities established that where documents that are the subject of legal professional privilege are disclosed to a third party by the person entitled to assert the legal professional privilege, which in this case was SCB and its officials, and that they were disclosed for a limited and specific purpose, then legal professional privilege is only waived for that limited and specific purpose, and as between the person entitled to assert the privilege on the one hand and the recipient on the other. Where that happens, the person is entitled to assert the privilege is fully entitled to maintain privilege against others. In conclusion, the judge was satisfied that the documents were privileged as a matter of English law at all material times. The documents were not unprivileged by reason of any documents being sought in order to further iniquity. Privilege was not lost when the documents were circulated, and it was not lost for the purposes of these proceedings when the claimants obtained copies of the documents in Thailand in proceedings to which SCB was not a party and of which it had no notice.
Thanks very much, Annabelle. Finally, this morning, we'll look at a case before the Competition Appeal Tribunal, during which applications were made in relation to a document which had been disclosed in the course of the proceedings. As we see on the slide, document FDC 775 had been disclosed by Football Data Co. to Sportradar and to Bet Genius and Genius Sports. Football Data Co. maintained that the document was subject to without prejudice privilege and had been disclosed inadvertently and was still privileged, while Sportradar insisted that the document was not privileged. So looking at the background to the applications, Sportradar brought a claim in the CAT alleging breaches of competition law by Football Data Co. and Bet Genius and Genius Sports. This is the Sportradar claim. After a decision of the CAT in 2020, Football Data Co. and Genius brought actions against Sportradar and other individuals in the High Court, alleging breach of confidence and breach of statutory duty in relation to trade secrets. This is the High Court claim. Sportradar raised competition law defences, and these were transferred to the Competition Appeal Tribunal. The CAT ordered that disclosure in the CAT proceedings would be provided concurrently with disclosure in the High Court proceedings as a single disclosure process to be carried out in accordance with the civil procedure rules. Document FDC 775 was disclosed by FDC to Bet Genius and to Sportradar. The document was a board paper, including Appendix 1, which contained the body of an email from an FDC employee to an employee of Genius. The board paper contained some redactions, but the email was unredacted. The original email had a heading of private and confidential and without prejudice, but this heading was not repeated in the copy of the email in Appendix 1 of the board paper. Bet Genius and Genius argued that the email should have been redacted on the basis that it was subject to without prejudice privilege or common interest privilege, whilst FDC said that the parts of FDC 775 were indeed privileged and had been disclosed inadvertently. Sportradar asserted that the document was not privileged and had been properly disclosed. In correspondence of which the email formed a part, Football Data Co and Bet Genius and Genius have been in dispute about an indemnity, which was ultimately settled in a deed of variation. The CAT decided that the original email was subject to without prejudice privilege in its entirety. Sportradar was therefore unable to use the email or the text of the email in Appendix 1 of the document 775 in the CAT proceedings or in the High Court proceedings. The tribunal was satisfied that the email formed part of a negotiation which was genuinely aimed at settlement of matters in dispute, and whilst the without prejudice heading on the original email was not determinative of the nature of the document, it was considered to be a strong indication that the email was created in an attempt to settle matters in dispute. The tribunal disagreed with the argument from Sportradar that the indemnity issue was so subsidiary to other commercial matters being negotiated, such that without prejudice privilege should not apply, and there's no authority for such an argument. Trying to separate matters in dispute and commercial matters would be impracticable and would lead to uncertainty about what was or was not part of the dispute, and this might discourage parties from seeking to resolve matters. So that concludes our run through of a crop of interesting cases on the issue of privilege from earlier this year, and which we hope has been useful for you. Each of the cases that we've looked at this morning serve as a useful reminder for all of us to give careful consideration to privilege issues in various aspects of our day-to-day work and in internal communications and communications with external parties. They raise issues around privilege which can be envisaged arising in the course of dealings with opposing parties, and when faced with a situation around creating new documents or communications in a contentious situation, careful thought should be given as to whether the test for litigation privilege will be met, or if there is a risk that documents might not be protected by litigation privilege. Similarly, consideration should be given to the possibility of arguments that privilege may be waived in relation to certain communications. So thank you again for joining this morning.